Richard, great to see you again. So thinking about the risks of infringing UK competition law, companies can obviously face very large fines. They can face the risk of antitrust damages actions, and that risk has increased massively over recent years. Contractual provisions can be unenforceable. You've got the cost and time of getting drawn into an investigation or litigation, and then reputational harm if an infringement is ultimately found. Individuals face personal risks, potentially criminal sanctions and personal fines, albeit in practice, direct disqualification is really the big risk for individuals in the UK. So there are a range of different risks of infringing competition law, and now we've got a new one under the Procurement Act. So what does that add in terms of the kind of risks or sticks to encourage compliance?
Well, it's an interesting development. It's the Procurement Act of 2023. And what this is saying, to put it as simply as possible, is that if you're bidding for public sector contracts, and if you're involved in bid rigging or other cartel activity, incidentally, not just bid rigging, but if you're actually found guilty of being in infringement of Chapter 1, then you can be debarred from competing for future public sector contracts. So, that's quite significant. If you're a building company in the construction sector and you carry out public sector contracts, this would be a very serious sanction. Incidentally, it is something that exists in other jurisdictions. I seem to remember in the Netherlands that they were doing this 10, 15 years ago.
Yes, it's obviously a new risk that will be really of concern to kind of companies who are kind of regularly bidding for public contracts. But it's important to emphasise, as you were just saying, that the conduct that can lead to a company being excluded, it isn't limited to bid rigging. So under the new regime, you've got mandatory exclusion captures all types of cartel infringement, and then you've got both non-cartel and cartel activity can lead to discretionary exclusion alternatively. And even equivalent foreign infringements are within scope. And suppliers should also be aware that they can be excluded because of relevant conduct by their associated persons or connected persons. So there's quite a bit of detail there. It's not kind of as simple as just thinking about bid rigging behaviour by yourself.
No. Well, as we know, any piece of legislation can start with a simple idea, and it turns out to be quite complicated in practice. But one very simple idea is that if you're actually found guilty by the CMA or another concurrent regulator, so you're actually found to have infringed Chapter 1, then that is mandatory exclusion from public sector tenders. And it may be worth saying, of course, that I think there is going to be a lot of public sector construction in the next few years. This government is committed to improving the infrastructure, and some of the contracts are going to be very substantial. So I can see that there's quite a big incentive not to be excluded from all of that. But let's be honest, the CMA does not adopt many infringement decisions. They're very few and far between, but that isn't to say that there isn't lots of illegal behaviour out there. I suspect there might be quite a lot. And so the discretionary ground for exclusion is where a public authority believes that somebody is infringing competition law, not just by bid rigging, not even just by cartel behaviour, but it could be in other ways as well. And there is then a discretion that they should be put on a list of debarred entities.
Absolutely. Now, obviously, the best way for a supplier not to find themselves excluded or debarred from bidding for public contracts is obviously don't commit an infringement of competition law and do what you can to prevent infringements by your connected and associated persons. But if an infringement does occur, there are certain steps parties can take to protect themselves from being excluded. So, in particular, immunity recipients receive automatic protection from being excluded, and there are also other steps parties can take to self-clean, as it's referred to. So what does the Act say about all of that?
Well, I think for people watching this video, I would encourage them not to go to see what the Act says, but rather to look at what the CMA in its recent guidance says: exclusion and debarment on competition grounds, what suppliers and contractors need to know, published on the 26th of February. It sets out the mandatory and the discretionary grounds for exclusion, but it then has a section on self-cleaning. And this is the idea that a company looks at itself, says, oh gosh, we have a problem, and then they can do various things to try to clean themselves up. I won't go through all the ideas that are here, but they do give examples, having training for their staff and employees, even conceivably changing staff and employees, and so on. So it's easy to understand what they're saying there, and I would think that that's where people should go to find out.
Yes, absolutely. That's nice and short compared to reading the Act, for sure.
Yes.
Thank you, Richard. That was very interesting.